Hello friends, welcome to this video where we will discuss the preamble of India's constitution in detail. Preamble of Indian constitution, also sometimes called as the keynote of Indian constitution, identity card of Indian constitution. Now, Constitution of USA was the first constitution to have a preamble. Many countries followed that. India also followed that. So USA is the first to have a preamble. The preamble of India has been amended only once. Only once. What is that? 42nd constitutional amendment, where it added these words: socialist, secular, and integrity. These are the four words that has been added with the 42nd constitutional amendment in the preamble, and the preamble has been amended only once. If you look at the preamble, you will see the preamble actually can be imagined to be composed of four parts. One is the authority of the preamble or the constitution, authority. Second is the nature of Indian state. Third one is the objectives of the constitution, and fourth one is the date of adoption. We will discuss these things in detail one by one. First is the source of authority. Source of authority is the people of India. We, the people of India. Now you see that the source of authority is not the Constituent Assembly, not the Parliament, not the President, not the Prime Minister, High Court, Supreme Court. These are not the source of authority of the Constitution. We at the people of India is the source of authority of the Constitution. The Constitution gets its power from the people of India. Now let's come to the nature of Indian state. The first is sovereign. Sovereign means India is not dependent on any country. On any country. India is member of WTO, India is a member of UN and many other bilateral and multilateral organizations, let's say BIMSTEC, SCO, Shanghai Security Organization. But being member of those does not mean that India is anyway lose its power uh, when it comes to the internal matter and to uh, conduct its business externally. You have seen the recently Article 370. It was a subject of informal discussion of UN. India had repeatedly said that no country has the authority to interfere in its affairs, and no country has not been able to do that. So it is the sovereign and the most desirable characteristics of any state. Now, the sovereign, you have to remember that the state of India or the country of India is actually sovereign. Not the parliament, not the high court, not the supreme court. They are the parts of the India, parts of India. They themselves, they are not sovereign, but the state of India is sovereign. the closest the sovereignty comes to, we can see that the pupil are the real sovereign, but not Supreme Court, High Court, Parliament. They are not sovereign. The next, now let's come to the next characteristic. Socialist. Socialist, it was added with 42nd Constitutional Amendment Act. Before that, the socialist values were implicit in directive principle of state policy. There also in 1955, after the session of Congress, advocated socialistic principle of society. Now, in socialism, there are two types of socialism. Socialism is of two types. One is communistic socialism. The other one is democratic socialism. In communistic socialism, all modes of operation is under the control of state. That means hospitals, the industries, the schools, the colleges, the universities, all under the control of the state. Example is former USSR. In democratic socialism, there will be public sector, that means the government, there will be private sector. The public sector and private sector will work in synergy with each other. This is called the democratic socialism. So private sector will work independently, it will have freedom, and public sector, that is government, will also give some services. This type of economy is called mixed economy, mixed economic model. And most of the countries in the world in today follow this mixed economic model. Now let's come to the secular. Secular also added with 42nd Constitutional Amendment Act. Before that, secular is was part of the, it was not mentioned, but in Article 25 to 28 in Fundamental Rights, Chapter 3, we will see in a later video, it explicitly discussed about freedom of religion, freedom to propagate religion, freedom to manage religion, not only individual but also society. So individual plus also society. So individualistic plus pluralistic. Now with 42nd Amendment Act, it has added in the preamble also. In secular, in a country, let's say country, in terms of religion, there can be a few parts. Let's say they are atheistic, theocratic, and secular. Atheistic means the country do not believe in any religion, do not affiliate in any religion, and actively condemn the religion, condemn any kind of religion. Example, former USSR. Theocratic state, the country upholds a particular religion. Example is Pakistan, Afghanistan, Indonesia. Secular country, they do not have any religion and they are equally respectful to all religions. So first characteristics is state does not have any religion. Second is equally respectful to all religion. This is our India. Many other countries like USA, UK, they belong to the secular category. Now let's come to the democratic. You see, the democratic means demo. Demo means pupil. A cratic comes from the word cratia. That means the rule. So the democratic means rule of the pupil. A democracy can be two types. Uh, Democracy can be of two types. One is direct democracy, another is indirect democracy. What are the characteristics of direct democracy? Referendum, plebiscite, recall, and initiative. Now let's discuss this. Referendum is that, let's say the government wants to make a market. Where the market will be, the government tells the people that you vote where the market will be. Or the government wants to make a bridge. uh, Government asks people that you vote where will be the bridge or what will be the color of bridge. So if there is a proposed legislation and put to vote, and where people decides, then it is called referendum. Plebiscite is also vote, but it is of different nature. It is uh, generally for uh, what to say. There is for to discuss this territorial disputes. So it is a vote, but it always happens in a non-democratic environment. Non-democratic environment. But referendum always happens in a democratic environment. uh, Plebiscite, you have seen that generally when Donald Trump came in power, California wanted to go out of American Union. So that is a plebiscite. Plebiscite always decides the, uh, for example, like a state, whether it will be in a particular country or it will form a new country or a new independent country, like that. Recall is that, let's say you are not happy, you have given vote to MPs, MLAs, with your vote they have been elected, and you are not happy with their work. So you say that your term is not finished, but you please resign. That it is recall. In some countries, citizens can do that if they are not happy with the work of MPs, MLAs, or not MPs, MLAs, but they are elected representatives. They say that you please resign, and we elect another representative. That is recall. Initiative, spelling is mistake. Initiative is where, let's say, a group of people want a law, then they call their MPs, MLAs, that we want a law and please pass it. Then MPs, MLAs go to the parliament and pass the law. So this is initiative. So the first initiative rests with the people of the country. In our country, can we do all these four things? No. So India is a indirect democracy. India is a parliamentary democracy. where we choose our representatives and they choose executives. The representatives among themselves choose the executives, that means the minister. The executives are responsible to the parliament. This is the nature of democracy. Democracy generally means that it is not only the voting power, not only the voting power, but all aspects of our being. All aspects of our being is considered in democracy. Republic. A democracy also, let's say a democracy can also be divided in the following way. One is monarchy, where the head of the state is hereditary. Head is hereditary. Hereditary. Other, the head is elected. Election may be direct election. Election may be indirect election. Direct election is USA. Indirect election is India. Monarchies, let's say UK, Nepal, Denmark. Here, where the head is elected, either directly or indirectly, is called a republic. Republic also means that the the characteristic is that head is elected, maybe directly or indirectly. Also is that the sovereignty rests with pupils. Rests with pupil. And secondly, all political offices are open to pupil. Political offices are open to pupil. Okay, so this is republic. So India has been the first two characteristics has been covered, that is the source of constitution, that is the pupil, and nature of Indian state, that is sovereign, socialist, secular, democratic republic. Now we see what are the objectives of the constitution. First is justice. Justice is the source, the inspiration of this justice is obtained from the uh, Russian Revolution. It happened just after First World War and was a great inspiration for our freedom fighters. 1917. Justice is of three types. It is social, economic, and political. Political. Social and economic justice also together is called distributive justice. The political justice is ensured with fundamental rights that we will see later, and social and economic justice is with directive principles of state policy. That means social justice is that no one will be but to on the basis of, let's say, color, the sex, race, place of birth and so on. Economic justice is that there will be no glaring inequalities of income, so there will be the equal income will be equally distributed, although they are not maintained in a in a way they should be, but this is the way constitution wants the country to be. So political is of course, all of us can vote, and once we obtain once we have a particular age and no one is barred from voting, that is our political justice. Let's come to liberty. Liberty is that you are independent to do, you are free to do anything. But this anything is really anything? No. There are certain restrictions. There, it is this freedom to free to do anything is fundamental rights, and this restriction also mentioned in the fundamental rights itself. So within the law you can do anything. So it is mostly it is article 19 and 20. We will discuss it in detail when we discuss the fundamental rights chapter articles. They are part of fundamental rights. Equality. Next comes the equality. Equality is again political equality, civic equality, and economic equality. Political equality is that right to vote, and we are that whatever our conditions, we may be poor, we may be rich, but one person has one vote, that is fixed. So this is why in a democracy we are equal, one person, one vote. Civic equality is that let's say there is a law and the law applies for law applies equally for everybody. So equality, let's say equality before law, equality. This is article 14, not only article 14 but article 14 to 18. They preach about civic equality. Economic equality in directive principles, it says that equal work, equal pay, equal work, equal pay. Men and women should get same remuneration. Men and women, same pay. They are the economic equality. Now let's come to the next, fraternity. Fraternity means what? Brotherhood. Promoted by what? Single citizenship. You see, we have only one citizenship, that we are all Indian. We do not have state citizenship. So when we say we are all Indian, we say when Bihari, Bengali, or let's say from Tamil, these things, Bihari, Bengali, Tamil, Assamese, these things does not have any meaning according to Indian constitution. All of us is only one thing, that we are Indian. This is fraternity. So we are all Indian. So we are all brothers. Fraternity also say that the dignity of the individual and dignity of the individual. There is in article 51A in fundamental duties, you will see that there is a one provision that say we have to we cannot make derogatory comments towards women, towards women. That ensures dignity, and it also ensures unity and integrity. Unity is what I already said, that we are all Indian, and also there are some provisions in Article 51A that says that we have to, when country calls, we have to go to country's cause, or we have to respect the national anthem, the national tradition, national the principles that uh, that is behind our freedom struggle, such things. Integrity is that it is both our psychological integrity and territorial integrity. Territorial integrity. Psychological is that we are integral whole, that we are all Indians. Territorial integrity comes in Article 1, the very first article. We will come in the next video, that it says that India is a union of states. Union of states, that means the states cannot go outside of the Indian territory, even if they want to. So that is the territorial integrity. Psychological integrity has already obtained, that we are all Indian, and also then it comes the territorial integrity. This is how uh, the the fraternity, yeah, justice, liberty, equality, and fraternity, the constitution aims to achieve. And they give like the preamble give like a sneak peek to the constitution. Date of adoption is 26th December 1949. This is her it is adopted. And 26th January 1950, when our uh, first Republic Day was celebrated, the Constitution was enacted. Here in this date, a few articles we will discuss in later videos. Few articles came into power, and here in this date, the full Constitution, it is the date of adoption, and 26 January 1950 is the date of enactment of the Constitution, where the full Constitution came in power. Uh, so we discussed the preamble, and the preamble comes before the very first article. So there was always a debate that whether it is a part of Constitution. If it is a part of Constitution, it can be amended, and if it is not, it cannot be amended. So we will discuss if three cases. One is Berubari case, 1960. The second is Keshavananda Bharati case, the famous Keshavananda Bharati case, 1973, and the LIC versus Union of India case, 1995. In Berubari case, the Supreme Court says that the preamble is important, and if there is any uh, between two articles, let's say there is a difficulty in interpreting, then the preamble can be used to interpret that article. So it is very important, but it is not a part of Constitution. So preamble is important in the preamble, but it is not a part of Constitution, not part. So if it is not part, there is no question of amendment. So then after that, the Keshavananda Bharati case, the Supreme Court reversed its opinion. It said yes, it is important, very very important, and it is a part of Constitution. So it can be amended. and if it can be amended only when there are certain basic principles are maintained. So it spoke about basic structure of constitution. So constitution preamble can be amended, but the amendment has to confirm the basic structure of the constitution. In LIC of India case, the Supreme Court again said that whatever we said in Keshavananda Bharati case is right. So presently it is the preamble is said to be the part of constitution. Also, the Constituent Assembly, when they uh, pass the constitution, at the end they pass the preamble, and so that the preamble is not frictional with any of the constitution, and the preamble was put to vote. Preamble in the Constituent Assembly was put to vote, and the subject was, the motion was that the preamble, whether or not the preamble is a part of constitution, and it was passed and it was decided it will be a part of constitution. So voted and passed as a part of constitution. Part of constitution. So we have two instances. One is Constituent Assembly. One is the support from the Constituent Assembly, and another is Supreme Court. So both of the organ say that it is, the preamble is part of the Constitution. But preamble is not a source of power of the Constitution. Let's wrap this. The preamble is very important, but not a source to power of, not a source to power of legislature. That means something is said in the preamble, but you cannot say that, oh, it is said in the preamble, so it must be that. It is not. So it is not justiciable. Like fundamental rights, justiciable. It is not justiciable. So it is not a source of power, and also not a prohibition to power. These things, please remember that preamble is very important. It is, but it is not justiciable. It is not a source of power to the legislature, so the parliament, and also not the prohibition of power. So whatever said in the preamble is like the sneak peek of the constitution. This is how the preamble is. Now we will solve a few questions. Let's say the constitution derives its authority from Parliament, Supreme Court, Constituent Assembly, People of India. The Parliament, what it does, it can amend the constitution. The Supreme Court, what it does, it interprets the constitution. Constituent Assembly wrote the constitution, but it is the people of India that is the that our constitution gets its authority from. So that is the people of India. Now let's say choose the correct statement. The preamble is based on objective resolution moved by Pandit Nehru. This is right statement. The constitution was adopted on 26 January 1950. This is wrong. This is not adopted. This is enacted. Enacted in 26 January. So our right answer is 1 only. Let's say this question, consider the following was there are given some words. You have to say the way it appears in the preamble. You see, these words are very important. This says the nature of India. What is that? The sovereign is the most, even if you don't know that, let's say you do not remember. So what should be the what should come first? First come has to this, let's say, the socialist, democratic, republic, secular, all actually comes later, but the sovereign is the most important characteristic of a nation, whether it is free nation or not. You know, you remember our freedom struggle. We wanted to become a sovereign nation. After we became a sovereign nation, we decided whether we should be socialist, democratic, republic, secular. So even if you don't know, you can figure out that it should be sovereign. So first it will come three. So option 1 and option 3, gun. Sovereign, then sovereign, socialist with added with 42nd Constitutional Amendment Act. Socialist is 1. So 3131. Then comes of seculars. These two are with 42nd Constitutional Amendment Act. Secular is 5. So B is our correct answer. Let's take the next question. Preamble is part of Constitution. This is right, but and it is justiciable. It is not justiciable. This part is wrong. Okay, so this statement is wrong. Preamble helps in interpreting the Constitution. It is right. Preamble has been amended only twice, not twice, it is once. It is wrong. Indian Constitution is the first constitution to have a preamble. It is not Indian Constitution. This is Constitution of USA. Is the first constitution to have a preamble. So this is also wrong. So our answer is B only. Let's say here there is only B. There is no option. So answer will be none of the above. In the next video, we will do this union and territory, union and its territory. You read the book Laxmikanth in the preamble and let me know if you have any problem or not. And if you have any comment, opinion, any suggestion, please write it down as comments. It will be very motivating for us. Thank you. See you in the next video.